Hi everyone, my name is Harris. I am a student at Osgoode Hall Law School. And for today's episode of Case Law Minutes, we're going to be discussing the case of Pecore and Pecore. Pecore and Pecore touches upon a number of different areas of law, namely family law, property law, and wills and estates. And the main point of this case is that it deals with the transfer of assets in joint accounts and the legal presumptions that may apply, particularly when it comes to accounts held jointly by parents and their children. Before we get started, just a quick disclaimer that this video is for informational purposes only. For advice specific to your case, please consult with a lawyer. In order for us to get a better understanding of what exactly is going on in the case of Pecore and Pecore, I want to begin with the concept of joint tenancies. Now, there are a couple of main features of joint tenancies. Firstly, it is property held by two or more joint tenants at the same time. Secondly, each joint tenant has an equal right to the entire property. And thirdly, and most importantly for our case, is the right of survivorship. The right of survivorship is a legal principle that essentially results in the deceased joint tenant's share of the property passing on to other surviving joint tenants. The right of survivorship is important because it is often used as a will substitute. Now, normally upon death, the assets of the deceased will become part of their estate, and that will be distributed by a will. However, ownership of property in joint tenancy is different in that the property automatically passes to joint tenants, with no will required. There are various advantages to this, most of which has come down to the fact that oftentimes it is more efficient and cost effective. Wills generally require you to pay a lawyer, there may be estate administration taxes involved for making a will, and joint tenancy is better at protecting your assets from creditors. For these various reasons, joint tenancies have been frequently used as a means of transferring property upon a person's death. I think that we can best understand the concept of joint tenancies through an example. And so here I've given the example of A and B who are joint tenants. A and B own 100% of the property, and they own it as a collective, meaning that it is not divided between them in any way. Now let's say that A passes away. The right of survivorship makes it so that B becomes full owner of the property. On this slide, I've given the example where A and B are not joint tenants, but are instead what we refer to as tenants in common. We see that the main difference is that each party has shares of the entire property. And here I've given the example of a 50-50 split. A owns 50% and B owns 50%. Now let's say that A passes away. A's 50% share is passed on through their will. So whoever A designates as their beneficiary will receive their share of the estate, and B will be able to hold on to their share, but will not be able to access A's. Now that we've gotten a better understanding of the concept of joint tenancy, we can delve into the particulars of the case. Pecore and Pecore begins with a father adding his daughter, Paula, as a joint tenant to his bank accounts. And the reason he does so is after receiving advice from his financial advisor and his accountant that he could save on taxes and other fees upon his death by doing so. However, although the father adds Paula as a joint tenant to his accounts, he maintains that he is the full owner of them. In effect, the father is saying that the only aspect of a joint tenancy that he wants to apply is the right of survivorship. While he is living, he does not want to share ownership of the accounts with his daughter Paula. Now, closer to the end of his life, the father makes a will under which Paula and Paula's husband, Michael, were to equally share in the residue of the estate. The residue of the estate is essentially all the property that wasn't specifically mentioned in the will. Now, the father doesn't add the accounts to his will because he assumes that through the right of survivorship, the accounts will automatically pass on to Paula. The father passes away, and Paula and Michael later divorce. Following the father's death and their divorce, Paula and Michael disagree on how the $1 million in the bank accounts are to be divided among them. Paula argues that she was a joint tenant of the account, and therefore upon the death of her father, the right of survivorship takes effect, and she immediately becomes the sole owner of the accounts. Michael argues that Paula was merely given the account in her dad's name, but that she was never really a joint tenant of the accounts, and this is evidenced by the fact that she was never given ownership of the accounts while the father was alive. Michael's incentive for arguing this is that because the will didn't mention the bank accounts, they would form part of the residue and would be split equally between him and Paula according to the will. The primary issue that the court had to resolve is, did the joint accounts go directly to Paula through right of survivorship, Or are they part of the residue that needs to be shared with Michael? To understand how the court answered this question, we have to begin with the concept of legal presumptions. Now, a legal presumption is essentially a default presumption that the law makes in certain situations. In other words, given certain facts, the law assumes certain legal outcomes. An important part of legal presumptions is that they can be rebutted. Now, hopefully the concept of legal presumptions will become a little bit more clear once we understand the two applicable presumptions at play here. These presumptions being the presumption of resulting trust and the presumption of advancement. These presumptions arise whenever there is a transfer of property with no money involved. In other words, when property is given for free. And the court asks, what does the law presume occurred here? This applies to our case because the father gives Paula joint tenancy of the bank accounts while receiving no money in return. The presumption of resulting trust essentially says that whenever there is a transfer of property for no money in return, then that property was transferred in order for it to be held but not owned. And I think this can become clearer with an example. Now let's say that A gives B $1,000. The presumption of resulting trust makes it such that the law presumes that B is merely holding the money for A, meaning that A gave the money so that B could hold it for them. And this means that B eventually has to give it back. As it relates to our case, this means that the father gave Paula access to the bank account so that she could hold it but not own it herself, and she would have to give it back when the father passes away and would have to give it to the beneficiaries of the will. The presumption of resulting trust is going to be the default for a majority of situations, except for when the presumption of advancement applies. The presumption of advancement only applies within the context of certain relationships, in particular, between husband and wife, and parent and young child. So if property is transferred and nothing is received in return within the context of these two types of relationships, then the presumption is that the property was transferred with the intent that it is to be owned by the recipient. I think an example will help clear things up a little bit. Let's say that a parent transfers $1,000 to their child. The law will presume that this transfer was intended as a gift, and it is not assumed that the child will have to give that money back. Notice, however, that on the last slide I focused on young child. That's because the court in Pecore emphasizes that the presumption of advancement does not apply to the relationship of parent to adult child. This means that Paula's situation does not apply, since she is an adult. Therefore, it is the presumption of resulting trust that will apply, even though it is between parent and child, it is parent and adult child. The presumption is that the father gifted Paula the bank accounts with the expectation that she will have to eventually give it back. Remember, however, that one of the key features of a legal presumption is that it can be rebutted, and the court in Pecore lays out how exactly we can rebut the presumption of resulting trust. That is by showing that the intent of the transferor at the time of the transfer was for the recipient to own the property. In order to rebut the presumption of resulting trust, Paula presented evidence of her father's intent for her to own the accounts and not merely to hold on to them. She presented evidence of her close relationship with her father, evidence of his intent to take care of her upon his death, and evidence of a discussion with his lawyers upon which discussed the estate assets not containing the bank accounts, which he believed would pass through the right of survivorship. Upon hearing Paula's evidence, the court ultimately decides that the presumption of resulting trust is successfully rebutted. What this means is that the accounts pass by right of survivorship from father to Paula, and that Paula is now sole owner and beneficiary of the bank accounts, and she does not have to share it with Michael. And that brings us to the end of Pecore. And there are some main takeaways that I hope that we can learn from this case, beginning with the concept of joint tenancies and the right of survivorship. Joint tenancies are a form of ownership in which joint tenants own the property as a collective, and a key feature of the right of survivorship allows the property to pass on to other joint tenants without need of a will. We talked about legal presumptions as being the default stance of the court when they are presented with certain facts. We talked about two presumptions in particular. Firstly, the presumption of resulting trust, which arises when property is transferred and nothing is received in return, in other words, a free transfer of property, and how the court presumes that the property was transferred with intent that it is to be held but not owned by the recipient. The presumption of advancement acts as an exception to the presumption of resulting trust. So when property is transferred and nothing is received in return, but the transferor and the recipient are either husband and wife, or parent and young child, then the presumption is that the property was transferred not to be merely held, but with intent that it is to be fully owned by the recipient. The court in Pecore, however, make it clear that the presumption of advancement does not apply to the relationship of parent to adult child. So, we had to discuss the concept of rebuttals and how the presumption can be rebutted with evidence that has to show that the intent of the transferor at the time of the transfer was for it to be owned and not just merely held by the recipient. If you'd like to learn more about the case, you can find it easily online through the Supreme Court of Canada's website, and here I've provided the legal citation for ease of access. Thank you so much for watching, and in case you're interested in more content like this, please check out the Litigation Help channel. This has been Hariss, and I hope you all have a great day.